For the record, Mr. Ayler Jr. does have an alternate residence, so he doesn't have to live in the same house with his dad at this time, Your Honor. Mr. Ayler is working at a temporary service. I'm not aware of any prior criminal history. I didn't have the opportunity to hear the swear to or anything like that or look at a police report, but my understanding is that there was no physical altercation between the may have been some assaultive behavior, kind of going both ways. So probably in the best interest of everybody, including Mr. Ayler Jr., that he not have contact with the complaining witness at this time. Mr. Ayler Jr. is working, but he's working at a temp agency. He does not have any money to post his bond. He has no criminal history that I am aware of, and he does have an alternate residence. I'm asking the court release him on a personal bond, Your Honor. No objection to no contact with the complaining witness or the location of the alleged incident.
Does he need a police escort?
Thank you so much, Your Honor. That was my next point, that he is asking the court for a one-time police escort to retrieve some personal belongings.
Okay. Detective Dukes,
Yes, Your Honor.
was there anything else that you might want to tell the court that I might have missed?
No, Your Honor, like you said, for criminal history, doesn't have any other assaultive things on his criminal history or very much of what I saw in general. So, up for your recommendation, Your Honor.
Thank you. Mr. Ayler Jr., you're going to get a $25,000 personal bond. Nobody has to pay you money for you to get out of jail. You are going to get a one-time opportunity with a police escort to go to your residence where your dad lives, you and your dad lives, to get some of your belongings. Do you understand that?
Yes, ma'am.
Okay. Again, $25,000 personal. Nobody has to pay you money for you to get out of jail. Obey the bond conditions, go to court and resolve your matter. Do you understand that, sir?
Yes.
Okay. That concludes your arraignment. You can step aside. Thank you, Inkster.
Thank you, Your Honor. I appreciate it.
Thank you. Taylor and Council Reagan. Council Stevenson, do you want to do the other two after Taylor, or do you want Council Reagan to do the interviews for the other two individuals?
If he's able to do the interviews, that would be great. If not, I can do them after we put Taylor on record.
Okay. Council Reagan, can you unmute? No response, so we're just gonna start and do the Taylor arraignments. Okay, Hinojosa?
Yes. Who did you want first?
Whoever you have.
I'll grab Ellis. Ellis, okay. We're gonna do Ellis first, if that's okay.
Sure, Ellis it is. And Council Stevenson, has anybody started interviewing the defendants in Detroit?
Yes, Your Honor. I think that may be what Mr. Reagan is. I know Ms. Reasanover is doing that. Mr. Reagan may be.
Okay. All right, appreciate it. Thank you, ma'am. All right. Hinojosa, is Ellis available?
They're grabbing him right now. He's on his way right now.
Okay.
No problem. They're right here, they're in the center of the camera. Right here.
All right, the gentleman in the brown shirt, what's your name, sir?
Mark Ellis?
Is it Mark Lewis Ellis?
Yes.
Thank you, Mr. Ellis. I'm Magistrate Chartea, sir. You're here on a criminal matter. Your case number is 822570214701. You have an attorney. Go ahead, counsel.
For the record, Your Honor, Janice Stevenson appearing on behalf of Mark Ellis. He stands mute, waives the reading of the information, asks that a plea of not guilty enter on his behalf. Mr. Ellis has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. court dates are February 10, 2025, probable cause conference, followed by preliminary examination, February 19, 2025. Both matters are at 9 o'clock at the Taylor District Courthouse. Understand that, Mr. Ellis?
Yes, I do.
Okay, Mr. Ellis, let me tell you some bond conditions. One, you are not to have contact with complainant Antoinette Ellis. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons, and you're not to go back to the Cherokee residence. Do you understand those bond conditions?
I do, Your Honor, but I need to get my medicine.
Hold on. And counsel, he can have a police escort if he needs one to get his belongings.
We would make that request at this time. Thank you, Your Honor.
Thank you. Okay. Now just understand, Mr. Ellis, those bond conditions can change, okay, until what I hear from your attorney as well as from Detective Hinojosa. Detective Hinojosa, tell me about Mr. Ellis, pending convictions, assaultive convictions. I don't need to know about traffic matters.
I don't believe there's any previous criminal history. Yes, I don't think, I mean, the only thing we're concerned about is no contact.
Okay. So we talking about no contact? Can he go back home?
No, not, we'll do the police escort. I'll talk to my supervisor about getting that arranged with Mr. Ellis.
Okay. So right now, even though he has no priors, there hasn't been anything from the complaint indicating he can come back home.
Correct. Until, yeah,
Okay.
it's court.
All right. Okay. All right. Counsel Stevenson, go ahead, please.
Thank you very much, Your Honor. As Officer Hinojosa has indicated, there's no prior criminal assaultive or non-assaultive. Sir Ellis never been in jail before. He's 58 years old, Your Honor. He has given me an alternate residence where he would live alone. There's a family home that he has inherited, so he'll go over there until they get this situation straightened out, and probably maybe even after that point. Mr. Hinojosa, as the court can see, has been charged with a 10-year felony and a 93-day misdemeanor, nothing in between. I believe that speaks to the people's position on likelihood of successful conviction on the top count. It's likely that all he's really going to be facing is this misdemeanor 93-day charge, and he's never been in jail before, has an alternate residence, is receiving disability, so he does not have any money to pay a bond. With the one-time police escort, I think that Mr. Ellis will be able to get some of the 10 medications that he needs to take every day. He is insulin dependent. We're concerned about his health and his safety, Your Honor. If he's not able to get that medication, get some clothes, get some mail so that he can take care of taxes and other things that are coming up important at this time. Mr. Ellis understands that a no contact order is the order of the court. It's not at the behest of somebody else. So if the complaining witness or anybody else is admits that the complainant wants to have contact with Mr. Ellis is not interested in violating a court order. So he's going to do what the court tells him to do and stay away from the complainant and the location of the alleged incident. We would ask the court to release Mr. Ellis on personal bond, Your Honor.
Thank you. Detective Hinojosa, anything else I needed to be informed?
No, whatever the court recommends for bond.
All right, thank you. All right, Sam is reviewing the investigation or the police reports, the allegations. There's nothing to indicate that Mr. Ellis was saying to the complainant, "I'm going to kill you." Nothing as to that. But it does appear that this happened just a couple of days ago. It looks like both sides were into some sort of verbal argument. And then it looks like the defendant said that the complainant was in some sort of aggressive manner, was walking towards the defendant in aggressive manner. But I also see is that the complainant's left face slightly red. Allegedly, there was several red marks on the complainant's neck. He's charged with strangulation, suffocation. Okay. So what I am gonna do, doesn't have any priors that I am aware of. So, Mr. Ellis, what I'm gonna give you is, I'm gonna give you $100,000 personal bond. Nobody has to pay any money for you to get out of jail. But if you violate any of the bond conditions, don't go to court, sir, when you are supposed to. Next time, it will be a monetary bond. Do you understand that?
I think so.
Okay, well, no, not I think so, is that you know. So even if the complainant wants to talk to you, you're under order that you cannot.
Okay.
Even if, so you can't talk to somebody and say, hey, if you say to a family member, friend, and say, go talk to the complainant about this, you can't. That's a violation of your bond condition.
Okay,
No contact means no contact.
all right.
You're under court order. She's not under. You are. So no firearms or any other dangerous weapons. You don't go to the residence. You can't even go there by yourself and wait for the police. You have to go to the residence with the police. So if the police say, well, we'll meet you there. No. You have to go to, even if you're parking in front of the house, you can't. So you have to go with the police to the resident, get some of your belongings, and that includes your medications or whatever else, that's fine. But you have to go there with the police. Do you understand that?
Right, with the police?
Yes, right with the police.
Okay,
Okay, so again, $100,000 personal bond. Please don't disappoint yourself by violating, because next time you may be sitting in jail and somebody needs to pay money for you to get out of jail. Do you understand that, sir?
yes, okay.
Okay, thank you. Good luck. You can step aside.
Here.
Your Honor, the next one would be Frank Bankhead.
Okay,
So it'll be about 2 minutes. Sorry, that was Fred Bankhead.
that's fine. As long as I got the last name is Bankhead. Counselor Reagan? Maybe he's doing Detroit.
Yes, Your
Oh,
Honor.
there he goes. Counselor Reagan, did you want to do Westland or Dearborn?
I mean, if you guys need me to, I mean, I will.
Well, it's up to you. They're in the waiting room.
Okay, I can. I mean,
Which one do you want?
are you done? Or have you finished? Or you?
No, we're still doing 2 more for Taylor.
I didn't put me. Put me either or, Judge. Just put me on one.
Okay. Let's do, okay. All right, let's see. Taylor, stand by. Yes, ma'am. Yes. I haven't gotten anybody else. All right, let's see, Westland. We'll put you in what's called the breakout room with a defense counsel, so you have an opportunity to talk to a defense counsel. So Westland, here we go. Westland it is. There you go. Push the button, Westland, so you can get into a room and speak to an attorney.
Sent that to me.
Okay, and
Reagan.
okay. Did I lose Taylor? I did not put Taylor in a breakout room. I'm putting them to the main session. Let's see if Taylor comes back. There we go. All right, Taylor.
Yes, Your
All
Honor.
right, Mr. Bankhead?
Yes.
Sir, Ms. Bankhead, I'm Magistrate Chartea. You're here in criminal matter. First of all, say your full name, including middle name.
Fred Antonio Marquise Bankhead.
Thank you, sir. Your case number is 822570215801. You have an attorney. Go ahead, counsel.
Janice Stevenson, on behalf of Fred Bankhead, stands mute, waives the reading of the information as to the plea of not guilty. Enter on his behalf. Mr. Bankhead has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 10, 2025, probable cause conference, followed by preliminary examination, February 19, 2025, both matters at the Taylor District Courthouse. Mr. Bankhead, you understand the court dates?
Yes, I do.
Both are at 9 o'clock. Bond condition, there's no driving on any automobiles, motorcycles, mini bikes, golf carts, anything that can be driven by gas or electricity, you are not to drive, operate. You understand that?
Yes, I do, Your Honor.
Okay. All right. Detective Hinojosa, tell me about Mr. Bankhead, not traffic matters.
Other than, he had a previous, conviction for, concealed weapons, CCW back in 19. Other than recent stuff, it's just the traffic warrants out of Taylor, and then looks like MSP and Easter.
Okay. So in reference to the fleeing, what I want to know, did anybody get injured?
No,
Okay, so was there any assaultive behavior?
it just that, we're at that intersection, it was just a near accident. There was no, official report made for any accident.
Okay. All right. Anything else I need to know, Detective Hinojosa? No?
No, Your Honor.
Thank you. All right, go ahead, Counsel Stevenson.
Thank you, Your Honor. I absolutely appreciate the court's question about assaultive behavior, and there's no charge of resisting, obstructing police officer, nothing like that, Your Honor. It's just that fourth degree fleeing and eluding, dangerous enough, but I believe has been absolutely and perfectly addressed by the court's prohibition against the operating of any motorized vehicles. Mr. Bankhead is he's employed, he's been on his job at a local packaging company for the last 2 years, Your Honor. But he has already secured an alternate way to get back and forth to work. So doesn't need to drive, won't drive, Your Honor. Mr. Bankhead has already, I think, missed a part of his shift. So he doesn't want to lose his job, because losing his job is going to cause him to lose his housing, Your Honor. He's already, because he's been in jail, missed the day that he's supposed to pay his rent. So does have 2 children in this community that he's helping to support, and he needs that job in order to be able to do that. Understands that he may not drive anything anywhere, Your Honor. And I think with that prohibition, Mr. Bankhead is not going to present danger to the community. Prior is non-assaultive, and it's from 2019, Your Honor. So I'm asking the court to release Mr. Bankhead, give him a chance to keep his job, give him a personal bond without a GPS tether, because we know that if he gets a tether put on him, first of all, that's not necessarily from driving, but that's also going to probably cost him his employment and then his house as well. So I'm asking for personal bond, Your Honor, without a GPS tether.
Thank you. Well, first of all, I see on his computerized criminal history that Mr. Bankhead, he has a prior fleeing 4th degree. However, it was dismissed under HIDA, and that was from 2022 out of Macomb County. So, Mr. Bankhead, okay, This court is going to give you an opportunity. You violate any of the bond conditions, don't show up for court, okay? You're going to be looking at a high monetary bond. Do you understand that?
Yes, Your Honor, I do.
Okay, so don't come up with an excuse, say, I had to do this, I had to do that. You better have a very reasonable explanation. If you violate any of the bond conditions, don't show up for court. Okay, so I'm gonna give you a $50,000 personal bond. And I'll say this, sir. If you look to buy a motor vehicle, if the cost of the motor vehicle is too good to be true, it's probably too good to be true, meaning that you shouldn't get involved. So if somebody says, hey, give me $500, I'll give you a 2025 Blazer. I'm sure you already know new vehicles cost more than $500. Do you understand that?
Yes, Your Honor.
So think about all this stuff as you're going about your life. Don't get involved with anybody that can get you in trouble, because you're already in trouble, and we want to keep you on the narrow so you can continue and stay out of jail. Do you understand that?
Yes, Your Honor.
All right.
Your Honor.
Thank you, sir. That concludes your arraignment. You can step aside.
Thank you, Your Honor.
Thank you.
The other guy in Yeah. Okay.
You have. Straight to here.
Sure, he's stand right here. Right in front of that iPad. Yep.
So what's your name, sir?
Henry James Tetnick.
Sir, I'm Magistrate Tuckdale. Sir, you're here at a criminal matter. Case number is 822570215001, sir. You have your defense counsel. Go ahead, Counsel Stevenson.
Janice Stevenson appearing on behalf of Henry Hetnick. Stands mute, waives the reading of the information. Asks that a plea of not guilty be entered on his behalf. Mr. Hetnick has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 10, 2025, probable cause conference, followed by preliminary examination, February 19, 2025. Both matters are 9 o'clock at the Taylor District Courthouse. Understand that, Mr. Hetnick? Court dates.
Yes, ma'am.
Okay, sir, let me tell you some bond conditions, sir. While this case is pending, you're not to have contact with your family members, Heather Calderwood, as well as Mary Hetnick. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any type of firearms, and that includes any toy firearms, no BB guns, no tasers, no pepper sprays. You're not to go back to the Cape Cod residence while this case is pending. Do you understand that?
Okay, I got.
Excuse me, Mr. Hetnick, sir.
Okay,
Will you please just answer the court and let her know whether or not you understand what she said, okay? If you needed to talk about something else, maybe we should go back to breakout, but please just answer the court's questions as to whether you understand or not.
That was just what the health of my wife or something.
Okay, can you just let the
Mr.
court
Hetnick.
know whether or not you understand what she said?
Yeah, I understood.
Okay.
Okay, Mr.
Thank you.
Hetnick, if you need to go back, get some of your belongings, medication, whatever. We will give you a one-time opportunity with a police escort. Do you understand that, sir?
Yes, ma'am.
Okay. Now, Detective Hinojosa,
Yes, Your Honor.
okay. Has anybody spoken with the complaints in this matter as to whether or not the bond condition should be changed to no assault of contact? You can go back to the residence.
Oh, yeah.
Have you heard any of that?
Or contact with the complainant in the case.
I'm sorry, say that again.
Yeah, just not going back to the residence and no contact with the complainants.
Okay. All right, so there's no new information. All right. Go ahead, Counsel Stevenson.
Thank you, Your Honor. Mr. Hentnick he's advised the court understands what the court's conditions are at this point, Your Honor. Mr. Hentnick just really wants the court to know that his wife, he has advised me, is gravely ill. He's not sure. Has recently been advised that she just has a very limited time left to live, and he's very concerned about her personal safety. But he does have a different address where he can live. Would live in a different city with a very, very long time friend, Your Honor. Mr. Hentnick does not have any money to post his bond. He is 67 years old. He has 12 to 13 medications that he has to take daily and has not received, according to Mr. Hentnick, any of those medications. The prior convictions, those that are not from the reporter's court, Your Honor, so I know the court appreciates the age of those. But even the other remaining prior conviction is, what is that, like 15 years ago at this point? So, you know, Mr. Hentnick is real concerned about his wife. He's asking for the one-time police escort. Thank you, court, for that. So his medications and other personal belongings, but he'd ask the court to consider no assault of contact. If that's not going to happen, he understands no contact, Your Honor, and we are requesting release on personal bond.
Thank you. I've heard the representations. Court uses clear and convincing evidence standard, and it's entertaining monetary bond. Court is considering, we started off with a personal bond basis. This is where, for you, counsel, and for Mr. Hentnick, is the allegations is that he ended up arguing with, I guess it's the daughter and the wife, about some money missing, somebody taking his money, okay, but more specifically, it's the concern that allegedly, okay, he has a firearm. It appears to look like a real handgun. They were BB guns. With that, supposedly the statement, he said, I should kill you now so I can get my money faster. And allegedly these statements were made while he had that facsimile firearm, kinetic gun in his hand. However, there was a real firearm, but that had been taken out of his residence without his knowledge. And supposedly, one of the complainants felt that they were in fear, thought that he would kill one of the complainants. So, Mr. Hentnick, you can't go back to the residence. No, you can't go back.
Only
Hold on, let me finish, Mr. Hentnick. One, you can't go back to the residence. You do have an, let me finish, sir, is that whoever your attorney is can make contact with the court, with the Taylor court judge, to see whether or not any of those bond conditions can be lifted or can be changed. But right now you can't. The other thing that I read in the investigative report is that medication, okay, before you were transported, your medication was taken to the Taylor Police Department. Okay. I don't know if that's some specific medication you need, but with all that being said, and even though you have some priors, those are from 1988 and 2010. Okay. I'm going to give you an opportunity, Mr. Hentnick. Well, before I goes to that, Hinojosa, was there anything else that I needed to know about Mr. Hentnick?
No, Your Honor.
Okay, so Mr. Hednick, I'm gonna give you $100,000 personal bond. Nobody has to pay any money for you to get out of jail. And I also take into consideration is you need some medication. Now, the jail may not be able to give it to you while you're in jail. I'm taking that into consideration. A lot of stuff may have been said while it was just in the heat of the moment. I don't know. I was not present. I only take what is presented in me, and I try to protect both sides. So $100,000, nobody has to pay any money for you to get out of jail. You have a one-time opportunity with police escort to get some of your belongings, including your medication. Do you understand that, Mr. Hednick?
Yes, ma'am.
Okay. Did you have any questions about your bond conditions or the court dates?
Well, not at this time. I'll go through my attorney.
Okay. Thank you. That concludes your arraignment, Mr. Hednick. Thank you. Thank you, Taylor. Thank you, Detective Hinojosa.
Thank you, Your Honor.
Thank you, ma'am. Okay. So, you ready on Westland? Okay, Westland. Okay, Mr. Wade,
Yes, ma'am.
have you spoken to a defense counsel
I'm ready.
earlier?
Yep, I'm ready with Mr. Wade, Your Honor. Thank you.
Okay, all right, thank you. Mr. Wade, please say your full name.
Earl Stephen Wade the third.
I don't even think people look. You're the only one that does.
Mr. Wade, this magistrate at Charte, you're here on a criminal matter. Case number is 822371397401. You have an attorney. Go ahead, counsel.
Janice Stevenson on behalf of Earl Wade III. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Wade has been advised of his rights, Your Honor.
Thank you. Also, Mr. Wade, you are defendant one in this case. I'm going to enter a plea of not guilty. Court dates are February 13th, 2025, probable cause conference, followed by preliminary examination, February 20th, 2025. Both matters 9 o'clock at the Westland District Courthouse. Understand those court dates, Mr. Wade?
Yes, ma'am.
Also, Mr. Wade, while this case is pending, bond conditions. You're not to possess any firearms of any kind. You're not to possess any ammunition of any kind, and you're not to possess any illegal controlled substances. Do you understand that, sir?
Yes, Your Honor.
Okay. With that being said, is there an Officer York there?
No, he's not right here. I can call him to have him come back here if you'd like.
No, I just need to know in reference to Mr. Wade, is prior felony convictions, anything that's recent, is he on probation, assaultive convictions?
Not that I'm aware of, ma'am.
Okay. Counsel, Stevenson, go ahead, please.
Thank you, Your Honor. Mr. Wade has given us a local address, Your Honor, has family in the community, including 2 children. The incident, as alleged, does have, a couple years on it, not a fresh case at all. Mr. Wade is advised he didn't know anything about these charges, Your Honor, before he was arrested just a couple of days ago. He is seeking employment, so he does not have any money to post as bond on these non-assaultive cases, Your Honor. The prior convictions are also they're pretty old themselves, Your Honor. None of them are assaultive. We are requesting release on personal bond.
Thank you. Well, what I see is a home invasion 2012, narcotics 2012, narcotics 2014. I see that this is, we're going to be going on to 2 years from this case. Date of offense, February 9th, 2023. Mr. Wade.
Yes, Your
Can
Honor.
you obey all the bond conditions? Go to court when you have to?
Yes, Your Honor.
Okay, I'm gonna give you a $25,000 personal bond. Nothing that I see to indicate, I didn't do the probable cause, so there's nothing that I see that you are a danger to the community. I don't hear anything new on you. I do see your priors, but nothing like that to indicate that you are a complete danger. So the last 2 years, I don't have anything new, so I'm gonna take a chance on you, sir. $25,000 personal bond. Nobody has to pay money for you to get out of jail. You understand that, Mr. Wade?
Yes, Your Honor.
Okay, that concludes your arraignment. Good luck. Thank you, Westland.
All right, ma'am. Do you have our email to send over his paperwork?
Hold on, Ms. Gwen? Do you have Westland's email?
It'll go back to the email that it came from.
So it will go back to the email that your paperwork came from.
Awesome. All right. Thank you.
Thank you. You have a good day.
You too.
Thank you.
Definitely.
All right, we got, let me call Dearborn. Because nobody's in the breakout room. Excuse me, nobody's in the Dearborn jail.
So now-
Want to go into a breakout room, correct? Council Stevenson?
Sorry about that. I'm sorry, Your Honor. Yeah, I need a breakout, please, with Dearborn.
Sergeant Kushner.
Yes, Dearborn, this magistrate at Chartea. I'm connected to your jail, but there's nobody in front. So
Okay, we will
defense
go.
counsel, Mr. Irvin.
All right, we will go grab him right now.
Thank you.
You're welcome. Bye.
Thank you. Council Stevenson, do you want me to put you guys in the breakout room right now? I don't know if
Yes.
it'll automatically go.
Yes,
But
please.
I
I
can try.
can go there and just wait for him. Yeah.
Let's see. Dearborn went automatically. I have to go through there. Council Ragnan,
Good morning, Your Honor. How are you?
or good afternoon, sir.
Or good afternoon.
We
I'm
have
sorry.
one more, we have one more out county,
Okay,
and then hopefully we can start with Detroit. So please
I'll be
bear
ready
with
to
me.
go.
Thank
I
you.
lucked out
Let's see
this
who this
weekend.
is.
I lucked out this
Pardon me?
weekend. I lucked out this weekend having you here this morning, today.
Oh, thank you very much. Appreciate it.
I enjoy
just
our
gonna
time
mute you.
together.
Thank you. Let's see, who's
Fine.
this?
Could you hear me at all?
I can hear you. I
Oh, I
can.
had you. Okay. All right.
No,
I'll
I
be
can hear
ready
you.
whenever. All right. I'll be ready
All right,
when
thank you.
Thank you.
Okay, Kyle Delaney, how can I help you? Please unmute. Kyle Delaney. Kyle Delaney, how can I help you? Kyle Delaney, this magistrate at Chartea, how can I help you? Again, Kyle Delaney, how can I help you? One more time. You're not muted, so you weren't muted when I was speaking to you. So let's try this other person. Is there an officer Delaney? Kyle
Yes, Your Honor.
Delaney?
Yes, Your Honor.
How can I help you?
I was here just for the arraignment of one of my cases.
Is this for Detroit?
Yes, Your Honor.
Okay, we haven't started, but okay. So the other on a Kyle Delaney, I can delete.
The other one is my work computer. I just don't have a microphone on it. I was primarily trying to use that.
Okay. Well, because I had that one and it wasn't muted, and then it went to ...
Yeah, I
But I
can
have
log
you
off of my
here.
phone that we're talking to right now, unless you actually, I'll stay on my phone and you can log the other one off. I don't have a computer
Okay.
microphone.
All right, so I am gonna remove this one. You still hear me?
Yes, Your Honor.
Okay, all right. What I'm gonna do is I'm gonna put you in the breakout room.
Sounds
Okay.
good. Thank you, Your Honor.
Sure. All right. Council Stevenson,
Yes, Your Honor.
ready on Dearborn?
Yeah, I think they're gonna need just a couple minutes for Mr. Urban, but the interview has been completed.
So I can close out the breakout room?
Yeah, yeah, if he's, yep, nobody else is in there.
Hey, you hear yourself? Yep, yep.
I do, that's so strange. How annoying it must be to hear that.
It's annoying to hear myself also. Okay, Dearborn, are you ready?
Yeah, he's in a restroom. 1 second, please.
Okay, no problem.
Sorry, Your Honor.
All right, the gentleman in Dearborn, please say your full name, sir.
Marvin Sanders.
I'm not looking for the detective or Sergeant Sanders, Corporal Sanders. I'm looking for the defendant to say his full name.
Oh, Michael Chad, ma'am.
Thank you, Mr. Irvin. I'm Magistrate Chartea. You're here, criminal matter. Case number is 8225702161-01, sir. You have an attorney. Go ahead, counsel.
For the record, Your Honor, Janice Stevenson appearing on behalf of Michael Urban. He stands mute, waives the reading of the information, asks that a plea of not guilty enter on his behalf. Mr. Urban has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court date is February 12, 2025. Pretrial at the Dearborn District Courthouse. Understand that court date, Mr. Urban?
Yes, ma'am.
Okay. Bond conditions, you're not to have contact with your wife, Paige Lee Irvin. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms, and you're not to go back to the Roosevelt residence while this case is pending. Do you understand those bond conditions?
Yes, ma'am.
Okay, counsel, does he need a one-time police escort?
Yes, please, to retrieve personal belongings.
Okay,
Other
so-
bond requests as well, Your Honor.
Okay, so, Mr. Irvin, you're gonna have a one-time opportunity with a police escort to get some of your belongings. Do you understand that, sir?
Yes, ma'am.
Thank you. And Corporal Sanders,
Yes, ma'am.
can you tell me about Mr. Irvin? Does he have any prior assaultive cases, convictions, pending cases?
No.
Okay. So, with that being said, Counsel Stevenson, you're gonna be asking for a personal bond, correct?
I am, Your Honor.
Okay, give me just a little bit more information.
Thank you, Your Honor. Mr. Irvin is a stay-at-home father. He and a complaining witness do have a one-year-old daughter together, and he's the primary caregiver for that child, Your Honor. Because of that, he does not have an income and does not have money to post as bond. But Mr. Urban does understand that he should have no contact with the complaining witness, that he should have no contact other than that with the police escort with the location of the alleged incident. Your Honor, Mr. Urban has been living in the state of Michigan for the last 2 years. He has pretty much focused all of his attention, devoted his time on his family. So he hasn't made like lots of friendships or anything like that, doesn't have another place where he can live in the state of Michigan. He'd asked the court if the court has ordered no contact with the location, and he's fine with that. He would just ask the court to give him permission to return to Houston, Texas, attend court from there by Zoom if he can. If not, he does have flight privileges, so he can make it back and forth to Detroit if he has to do that. But he just doesn't have any place to live between now and February 12th, first pretrial conference date. Certainly understands that he should have no contact with the complainant, is not trying to go to jail, not trying to violate the law, not trying to do anything that's going to compromise his relationship with his one-year-old daughter. So he'll be in court like he's supposed to, and he'll keep his distance from the complainant as well. He just asked the court to let him go to Texas where he'll have a place to live.
Okay. Corporal Sanders,
Yes, ma'am.
input as to that issue?
I can't hear you. I'm sorry.
Any input as to that issue?
No, I concur with the defense counsel says, and it's the same thing that Mr. Urban conveyed to me. It appears to be accurate.
Okay. All right, so then, there's no reason why he can't go back to Texas. Okay, so, Mr. Irvin, you're allowed to go to Texas, which is where you have other family members. Is that correct?
Yes, ma'am.
But I will say this, sir, okay? I'm taking a big chance on you. And the reason I say that is that according to the police report, there have been a number of calls the police had to make from May 2023 up till January 30th, 2025. 1, 2, 3, 4, 6, 7, 8, 9. From May of 23 to January
Mr. Urban,
30th,
wait a minute.
there had been at least police calls had to go out dealing with family trouble. So I'm going to allow you to go back home. You got family there. However, sir, and taking a big chance simply because that there may be where there's a flight risk, but I don't have anything to indicate that you will fly away. You will not come back to court. So
Judge, can I just say,
$25,000.
can I just say one thing? Mr. Urban wants the court to know. Thank you so much for being so thorough with your analysis, Your Honor. Mr. Urban is just itching to let the court know that at the very least, 2 of those calls that the court has referenced, probably more than that, but at the very least, 2 of them happened the same day as this alleged incident. He called the police and the police came out a total of 3 times. It was only the 3rd time that they came out, that he was the one who was actually arrested, but they came out twice the same day because he called them. And that's just what he wants the court to know. And for that, he's not going to do anything that other than what you're telling him to do, Judge.
Okay, so Mr. Irvin, go to court when you have to, obey the bond conditions. When you got to come back to court, come back to court. Do you understand all that? Before we get into anything else, but you understand everything I've said?
That's just one question. With
You understand everything I've said so far?
Well, I didn't understand one thing. Am I going to be going on a Zoom call in Houston, or do I need to come back to Detroit?
I don't know, but you understand everything that I've said so far?
Yes, ma'am. Sorry.
Okay, hold on. Ms. Gwen, for his Dearborn, is his first hearing Zoom or in person?
Which county?
Wayne County is Dearborn.
I mean, which?
Dearborn?
Which?
19th District.
19th District.
Yes, ma'am. And Mr. Irvin, I am going to let you ask something, whatever it is you want to ask, but I want to make sure that you're aware if it's either an in-person or it's a Zoom call.
PCCs are virtual exams are in person.
Okay, so your first court date is by Zoom. Your second court date is by in-person. Do you understand that?
Yes, ma'am.
Okay, what's your question?
What is, I know you guys don't have anything to do with my daughter, but I'm just concerned about my daughter in the meantime.
Well, you can't do anything about that. That's an issue that would have to go with family court. The other thing is, because you are married to the complainant right now, you can't have, basically, you can't have contact with her because you're going to be leaving the state. The other thing is, you can't have contact with your wife before you leave. I will allow contact with the daughter. If it's a daughter.
Yes, please.
Okay, that will be through a third party. Now, however, if your wife does not want you to have contact with your daughter, I can't do anything about that. Do you understand that?
Yes, ma'am.
Okay, so if the complaint agrees, you can have contact with your daughter through a third party. Do you understand that? Okay. Council Stevenson, you want to add anything?
I just want to encourage Mr. Urban to work with the officers there at the jail and contact the 19th District Court himself to make sure that I did hear Madam Clerk say that PCCs are on Zoom, but this is a pretrial, this is a misdemeanor. So I don't know if they have a different
Oh, that's
procedure.
right. Pre-trials, are they in? She's gonna check. Thank you very much,
Okay.
Council Stevenson, for letting me know.
Yeah.
Thank you very much, Council Stevenson, for letting me know. I'm sorry. Say that again, ma'am?
We don't have, information on pretrial.
Okay, so, all right. So you're gonna have to call the court, sir, to make sure. Okay. Third party can only contact the complainant. If the complaint agrees, you can have contact with the, with your daughter through a third party. That means somebody has to, you cannot have contact with the complainant, your wife. But for you to have contact through, with your daughter, it has to occur through a third party. And the complaint has to agree. You understand that, sir?
Yes, ma'am. Yes, Your Honor.
Okay. All right. All right. Anything else?
Nothing on behalf of Mr. Urban. Thank you, Your Honor.
Corporal Sanders, anything else?
No, ma'am.
Okay, that concludes your arraignment. Thank you.
Thank you.
Thank you. Thank you, Your Honor.
Thank you. All right. And Council Stevenson, are you gonna check to see whether or not you're ready for Detroit?
Yep, checking right now.
Okay. Here we go. Here's Westline, I believe. Officer Delaney,
Yes, Your Honor.
who do you have?
Xavier Braxton.
Okay, thank you. He's on the list, so,
Thank you, Your Honor.
all right. And Council Stevenson?
Detroit is ready.
Okay, I will also tell you, number 4 on page 1 is not going forward.
Got it. Okay, thank you.
Okay, because that's a misdemeanor. It's not a domestic violence. It's a non-domestic violence misdemeanor. All right.
Good afternoon, Ms. Stevens.
Mr. Ragnan,
How are
Happy
you?
New Year. I don't think I've seen you this year.
I
If
haven't.
have, Happy New Year anyway.
Happy New Year to you as well. How have you been?
Busy.
I just got to say good morning to Mr. Ragnar.
Here,
Good
Mr.
afternoon.
Reagan, good morning.
Good to see you. Good afternoon.
Yeah, good afternoon. I'm sorry. You know, I almost sent you a text and I said, you know, it usually comes down on Sundays, I thought, but I think I had it reversed. You come on Saturdays and not Sundays. That's right.
I'll be here on Sunday too. I'll be here on Sunday too. Yeah.
You know, you are an inspiration. I want you to know that.
Yeah.
To do what?
To work hard and do, you know, I mean,
Okay,
he sets
that right
a
there.
great example for the team, doesn't he? And for me as well.
Absolutely, Mr. Ragnar. I appreciate that, Mr. Ragnar.
Well,
Mr.
you
Stevenson,
do.
listen to Mr. Ragnar. Listen to what he's saying.
Actually, I can't listen right now because I'm busy putting this stuff in order that you gave me.
Okay.
So I got to work
Well,
on that.
Okay, I will say everything is that everybody is an inspiration. And
Thank
Council
you.
Reagan,
Yes,
take some
ma'am.
tips from Council Stevenson.
Yes, I will. I will. Your Honor.
Oh,
I
hey,
take them
but you
also.
all inspire me to come to court. Thank you.
Yes,
And
you,
I'm
got
happy when I
D3
see
now?
all these people here in court today. This is a very nice group of people. This
Okay,
couldn't be
we
better.
don't have, okay, folks, we don't have any retained counsels. Number 4 on the list, a female, that is misdemeanor. It is not a domestic violence. That is taken off the list. So that means, as far as I know, we got all males. DDC, good afternoon, sir.
How you doing, ma'am? Who's taking off the list?
Number 4, Iris Humes. How you doing, Officer Prey?
All right, and you?
Hey, Pray.
Hello there.
Hello.
I can't see you.
Good afternoon.
Okay.
Good
Hello,
afternoon.
sir. Got one page that's almost all DDC, I mean, all
Hey, Miss
CCWs.
Stevens, I got your memo. Everybody's personal bond. Is that what you told me to say today?
Okay, is that what you're saying, personal bonds?
Okay. Anything for you.
All right. All right, we have gentlemen in a pink, hot pink shirt, sweatshirt. What's your name, sir?
It's Ray.
I like it. I like it. What's your name?
Robert Thomas.
I didn't hear
Say
you.
that again?
Robert Thomas McCollum.
McCollum.
Number 8.
Oh, Mr. McCollum,
Okay.
you're the last. Okay, Mr. McCollum, okay. You're here. Case number is 250-556-0401. I'm Magistrate Torte. You have defense counsel. Go ahead, counsel.
Janice Stevenson, on behalf of Mr. Robert McCollum, stands mute, waives the reading of the information. As to the plea of not guilty in his behalf, Mr. McCollum has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Robbins. Mr. McCollum, you're not to possess any firearms, other dangerous weapons. You understand that?
Understand.
Okay, Council Ragnan, this is CCW. Give me a recommendation.
Good afternoon, Your Honor, and Ms. Stevens. Again, Samuel A. Ragnan, P23-157, on behalf of the people. The people are asking for a $5,000 personal bond, Your Honor.
No objection?
None at all. Thank you, Your Honor. Thank you.
Okay. Thank you, Mr. McCollum. You're going to get a $5,000 personal bond. Nobody has to pay any money for you to get out of jail. Go to court, handle your matter. Good luck. You can step aside.
Appreciate you.
Sir, what's your name?
Brian Keith Trim. Brian Keith Trim.
Okay, Mr. Trim, I'm Magistrate Torte, sir. You're here in a criminal matter. Case number is 240-586-8801, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson, on behalf of Brian Trim, he stands mute, waives the reading of the information. As to the plea of not guilty in his behalf, Mr. Trim has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Let me give you the court dates. First court date is February 11th, 2025. Probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Taylor. Mr. Trim, let me tell you some bond conditions. First of all is you're not to possess any flammable liquids. You're not to go back to the 14587 Evergreen in the city of Detroit, and you're not to have contact with the complainant, who is, let me see if I can pronounce it, Ayodiki Adenekten.
Pretty good.
Do you understand those bond conditions, sir?
Yes, ma'am.
All right, so with that all being said, this is from September 2023. This is more than a year ago. Council Ragnan, recommendation, please.
Well, Your Honor, people are going to ask for a $50,000 personal bond. Well, we're going to ask for a tether, but since it's so old, there's no contact. That's all we'd like. But it's just a terrible situation. There's pictures of this man setting this vehicle on fire. There's a situation where the complaining witness bought the house from him, and now they're suing each other because it was on land contract. So number of problems, but please, no contact. Thank you.
Well, I got a question for you. Since you won, you said a GPS tether?
No, he hasn't done anything in a year. I think I'm going to just let that go.
Okay, so $50,000 personal bond, no
Yes.
objections, correct, counsel?
No
Stevenson?
objection to that. Ask the court to adopt that, Your Honor.
Okay, thank you. Mr. Trim, you're gonna get a $50,000 personal bond. Nobody has to pay any money for you to get out of jail. Any violations? You next time may be a monetary bond. Do you understand that?
Yes, ma'am.
All right, that concludes your arraignment, sir. You can step aside.
Say it for me. Jalen Elijah Weaver.
Thank you, Mr. Weaver. A magistrate at Chapter here, criminal matter, case number 250-553-6701. You have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Jalen Weaver. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Weaver has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Jefferson. Mr. Weaver, some bond conditions. You're not to possess any firearms or any other dangerous weapons. You're not to have any contact with the complainant, Quinnell May. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand those bond conditions, sir?
Yes.
I will also say, this is for Counsel Ragnan. This is from April 2024, maybe about 8 months ago. Go ahead, ask for your bond recommendation, sir.
Well, people are asking for $100,000 cash surety bond. He's able to post that. We're asking for a tether with home arrest. Very serious matter, Your Honor. The complaining witness was sitting in a vehicle with another person. Allegedly, this defendant pulled up next to him and fired his shots at the vehicle, at least 2 shots. The photo lineup was captured on a body camera, but I believe, Your Honor, that I thought there was a video of this. I'm not sure, so I'm not going to say that. Except we have the complaining witness who can identify the defendant, Your Honor. And he also has, this is a half second, he has the receiving and stolen property, receiving motor vehicle, concealing 4/12/17. He has a embezzlement on HIDA on 2/15/2020, police assault, resisting, HIDA. He's got a pending B&E case, I believe, that from 4/28/24, Your Honor. So I think that the $100,000 cash surety, because this is a dangerous person to pull up next to someone and shoot at them, if their car right next to them, I think is very dangerous. Luckily, somebody wasn't hurt or killed. Thank you.
Thank you. Go ahead, counsel.
Your Honor, are we arraigning Mr. Weaver on one case or 2?
Just one.
Page 1. And does Mr. Weaver have another case?
I have a case number.
No.
Okay.
Oh, there's another case. No, if it's a misdemeanor, it's not going forward.
Okay, I understand. I only asked that because I believe that that case is the pending case that the people have referenced. So he doesn't, to my knowledge, other than that case that he hasn't been arraigned on yet, I wouldn't call that a pending case. But Mr. Weaver is employed at this time, Your Honor. He just started a pretty good job on September 23rd of this year. He's given us a work schedule, Your Honor. He works, I think like Sometimes he works like 12-hour shifts, and they flip that every other week, whether it's going to be working days or whether it's going to be working evenings. And we believe that he can overnight, and he can provide proof of that. The case does have some age to it. Mr. Weaver has no objection to a no contact condition with the complaining witness in this matter. The prior convictions that bring about the second notice, Your Honor, are non-assaultive. So I don't have anything and I don't have any case. Yes, ma'am.
No, go ahead, Council Stevenson.
I don't have anything to indicate any capious history, so there's nothing to show that Mr. Weaver won't come to court like he's supposed to and abide by any other bond conditions. I'm asking the court to release Mr. Weaver on a personal bond. I would unfortunately, due to the serious nature of the charges, I guess I would not have an objection to a GPS tether, asking definitely he'd be allowed the opportunity to go to work, Your Honor. But I don't think a cash bond is necessary with the no contact condition, Your Honor. And I'm asking for personal bond.
Thank you. Court heard the representations, both sides use the clear and convincing evidence standard. When it's entertaining a monetary bond, we started off with personal bond basis. The charges are serious. This is allegedly from April 2024, over 6 months old, less than a year. So between 6 months and a year old. The allegations are that the complainant was in a motor vehicle. That motor vehicle was struck by bullets. The also allegation is that as a complainant drove away, Mr. Weaver was following the complainant, Mr. May. However, there was photo lineup. There was 80% sure that it was Mr. Weaver. Nothing else to indicate on this. I don't have any new information. Do you have any new information, Council Ragnan?
I do not.
No. So what we're going to do is, for Mr. Weaver, you're going to be placed on a GPS tether, work only. And I am going to give you $100,000 personal bond. Sir, if you violate any of the bond conditions, you don't go to court, you violate the tether conditions. Next time, sir, you're going to be sitting in jail because your bond's going to be high, a monetary bond. Do you understand that, sir?
Correct.
Okay. Sir, you can step aside.
Come on.
What's your name, sir?
Deshaun Anthony Orr.
Sir, Mr. Orr, this magistrate at Charte, here in a criminal matter, case number 25055600001. Sir, you have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Deshaun Orr. He stands mute, waives the reading of the information, asks that a plea not guilty be entered on his behalf. Mr. Orr has been advised. Right, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination. February 18, 2025, both matters in front of Judge Giles. Mr. Orr, bond conditions. You're not to possess any firearms, other dangerous weapons, and you're not to have any contact with a Mr. Dwight Weston. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You understand those bond conditions, sir?
Yeah.
Also, sir, I don't want you going back to the Meldrum residence.
Okay.
Understand that?
Yeah.
All right, Council Ragnan, give me a recommendation.
Yeah, we're going to be asking for a remand. This is an armed robbery. The defendant and the complaining witness were squatting at a residence. Allegedly, the defendant had been stealing from the complaining witness's bridge card. And when the complaining witness found out, he got new cards. The defendant put a 38 gun up to his head and said, "Give me your bridge card." Do it. People that were squatting also at the residence were able to stop him from anything further. And there was allegedly someone took part of a video. I have no idea what that is.
Go ahead, counsel.
Your Honor, I'm asking for personal
Very
bond.
serious matter. Put a gun up to his head and would be. Pardon me?
Okay. No, I said go for Stevenson. If I said your name, sir, I apologize. Are you finished, Counsel Ragnan?
Yes, I am.
Okay, go ahead, Counsel Stevenson.
Okay, thank you, Your Honor. So, I am asking for personal bond. It seems like, the entirety of the people's cases is resting upon the credibility and the reliability as a witness, Your Honor, of somebody who admits that they're living someplace that they weren't supposed to be living, whether or not Mr. Orr was doing that or not. I guess that's, for somebody else to determine. But the people's entire case rests upon the testimony of somebody who was living in a house as a trespasser by his own admission. So I think a prohibition of contact with that location is appropriate. The matter is alleged, there's a little bit of time on it. So the priors for Mr. Orr are non-assaultive. We don't have anything to indicate that he won't come to court like he's supposed to. We don't have anything to indicate that he's a danger to anybody. The only person who's going to talk about this case would be the people's witness, and somebody who's living someplace where he's not supposed to be in the first place. So we're asking for personal bond for Mr. Orr, going directly to the likelihood of successful conviction on this case.
Okay, thank you. Court's heard the representations, both sides. Court uses clear and convincing evidence standard in this particular matter. Whether, and the court has looked at the allegations in the investigative report, whether somebody is squatting in a home, whether they're a trespasser, that's not, court takes that into factor. Court also takes all the allegations into factor in this particular matter, in which apparently the allegation is both the complainant and the defendant were squatting in this Meldrum home. There was other people that were squatting, okay? And that it appears that it says, okay, that it looks like the allegations that Mr. Orr had taken the complainant's personal property. The complainant found out he got some new personal property. We're talking about new cards, bridge card, social security card. And then apparently Mr. Orr is accused of attempting to rob Mr. Weston. Allegedly, there were other people that stepped in, and Mr. Weston made a positive identification through a photo. Court's heard enough. Court finds that, and this is just from December, less than 2 months. So the court finds that Mr. Orr is a danger. Okay. While this court, as to armed robbery, has the ability to remand him, okay, we're going to give him an opportunity, and we're going to give him $100,000 cash surety. We're also going to place him on a GPS tether, house arrest. But also, because it's an amount unaffordable, is that correct, counsel?
It's absolutely unaffordable.
So that means he's going to get another court date for this Monday. It's going to be February 3rd, 2025, 36th District Court, 9 o'clock in front of Judge McConaughey, Judge Williams, who'll look at the bond amount and bond conditions.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Thank you. You can, okay. Step aside. Got a minute, DDC, stand by just for a moment. Okay. Ms. Gwen, I added a little bit more information on the contact about through a third party. He can't have contact with complainant. Yeah, but he can see the daughter if the complainant agrees and the third party has a child. Okay. That was Mr. Urban, yeah. Gentlemen at DDC, what's your name?
Andre Maurice Meredith Jr.
Sorry.
Andre Maurice Meredith Jr.
Okay, Mr. Meredith, I'm Magistrate Chartesser, here criminal matter, case number 250-556-0201. You have an attorney, go ahead, counsel.
Janice Stevenson appearing on behalf of Andre Meredith. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Meredith has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 11, 2025. Probable cause conference followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Robbins. Mr. Meredith, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand all that?
Yes, ma'am.
Okay, Counselor Ragnan, this is not assaulted, CCW. Give me a recommendation, please.
Well, people are asking for a $10,000 personal bond, Your Honor.
Thank you. This court
No
is
objection
assuming
to that.
Counselor Stevenson is not objecting. So,
I'm not,
Mr.
Your Honor.
Meredith, you're going to get.
I'm sorry, I didn't get the PCC date, Your Honor.
That's all right, I'll repeat them. February 11th, February 18th, both court dates. Mr. Meredith, you're getting a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Do you understand all that?
Yes, ma'am.
Go to court, resolve your matter. Good luck, sir. You can step aside. What's your name, sir? Dimitri Tyler Echo, sir?
Yes.
Sir, you're here. I'm Magistrate Charter. You're here on a criminal matter, sir. Your case number is 250-556-0501. You have defense counsel. Go ahead, counsel.
Janice Stevenson appearing on behalf of Dimitri Eccles. He stands mute, waives the reading of the information. After the plea of not guilty and on his behalf, Mr. Eccles has been advised of his rights, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Jefferson. Mr. Eccles, while this case is pending, you are not to engage in any combative or assaultive behavior. Do you understand that, sir?
Yes.
Also, no firearms of any kind. You understand that?
Yes.
Okay. All right. Counsel Ragnan, go ahead with your recommendation, please.
Yeah, people are going to ask for a $50,000 personal bond. We're also going to ask for a tether with a. The reason for this is, I'm sure you've read the 11/22/24. He pled guilty to police assault, resisting, and obstructing, and is on 2 years probation for that. He's on probation for the same thing, and here we have it happening again. And so I think that puts him in a situation where he could be a danger. And I'm asking the court to put a high personal bond, but a tether with the person.
Okay. So I got a question for you.
Yes.
In this case, was there any assaultive or combative behavior with the police?
Well, it just says in here that they ordered the man to the ground because he had a magazine in his hand, or he discarded it. He gave him verbal commands to the subject. He grabbed the officer's uniform and pushed him away. That seems to be the extent of it. Well, hold on.
The extent. Okay. All right.
Well, then they had.
Go ahead, counsel. I'm sorry.
No.
Was there other stuff?
Sorry.
Okay,
That's enough.
thank you. Apologize, Council Reagan, did you want to add anything else?
No, nothing further. I apologize. Going on.
Thank you. Council Stevenson, go ahead, ma'am.
Mr. Eccles is working at this time, Your Honor, doing construction, Your Honor. So, he works 6 a.m. until 4:00 p.m. We want him to be able to stay employed so he can, comply with any other conditions of the other probation, Your Honor. I know he's gonna have costs and fines, probably, of course, he has to pay for. Want him to remain in compliance with that. I don't know of any capious history, Your Honor. We would concur with the request for personal bond. Ask the court to forego the tether at this time, Your Honor. I know that Mr. Eccles circuit court probation, so they'll know his whereabouts, but so no problem with personal bond, but I'd ask the court not to do tether at this time.
Okay, thank you. Mr. Eccles, my understanding is that you're on probation. Please don't respond, whatever it is, to a similar type of offense. So what I'm telling you, sir, is that, you know, if the police are approaching you and they're investigating something, please contain yourself. Don't be any combative or assaultive behavior or manner, okay? So in this matter, okay, I'm gonna give you a $50,000 personal bond. Nobody has to pay any money for you to get out of jail, okay? However, sir, if you violate any of the bond conditions, you pick up another case, next time this may turn into a monetary bond. Do you understand that?
Yes.
And the reason I'm not gonna put you on a tether is because I didn't see that there was any combative. You're just not paying attention to police instructions. So had there been some sort of fight, somebody had got injured, or any of that information or other information, you may be looking at a monetary bond, or you may be looking at a tether. But today I'm not gonna do that. Do you understand that?
Yes.
Okay, so $50,000 personal bond, no tether at this point in time. Go to court when you have to, sir. Take care of your matter. Thank you. What's your name, sir?
Examine Reese Braxton.
Okay, Ms. Braxton, this is Magistrate Chuck Bassler. You're here on a criminal matter. Your case number is 250-555-8201, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Xavier Braxton. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Braxton has been advised of his rights, Your Honor.
Thank you. And Mr. Braxton, just so you understand, you are defendant one in this case. I'm gonna enter a plea of not guilty. Court dates are February 12th, 2025, probable cause conference, followed by preliminary examination, February 19th, 2025. Both matters are in front of Judge Jefferson. Let me tell you some bond conditions, Mr. Braxton. Okay, you're not to possess any firearms or any other dangerous weapons. You are not to have contact with an Alfonso Martel Jones. That means no person-to-person contact, no contact to third parties, no phone calls, no emails, no text messaging. Do you understand that, sir?
Yes, ma'am.
Okay. Counsel Ragnan, your recommendation?
Well, people are asking for a remand, Your Honor. Very serious matter. This defendant allegedly, along with two other defendants, went with the intention, pursuant to this defendant's own words, to rob the complaining victim of a gun. When they met the complaining witness, he got out of his vehicle, came up to the windows of the defendant's vehicle who was driving, and two men in the back got out of the back seat and pointed a gun at him, at the complaining witness. The complaining witness then took off, and he heard shots, and then he was shot in the arm and in the chest on the left side of his body. I believe it was maybe shot one time that injured the left flank side of his chest. So he was in serious condition at the hospital, Your Honor. Subsequently, the defendant was apprehended, and he admitted that they went to meet the complaining witness to rob him. He admitted who the two people were in the back. They didn't know that they were going to shoot him, but the fact remains this is an armed robbery. Very serious matter. Yes, someone that's hurt very seriously. They did find 9mm slugs, and they found a 9mm gun at the defendant's residence. That had a, I believe, but be that as it may, Your Honor, I believe a remand is appropriate in this situation.
Thank you. Go ahead, Counsel Stevenson.
Definitely disagree with the remand, Your Honor, unless I was reading too fast. It looks like the alleged shooters in this incident are somebody other than Mr. Braxton. That would be corroborated by the complaining witness, Your Honor. Mr. Braxton is 20 years old. I think he's either in the National Guard or trying to get into the National Guard at this time, Your Honor. Was working at a local factory, but doesn't have any criminal history that I am aware of. It looks just at first glance from the investigator's report that the culpable parties are somebody else, Your Honor, and that Mr. Braxton was completely cooperative with the authority. So I definitely believe that remand is out of order here. And I'm asking the court to consider personal bond. I'd have no objection to house arrest, Your Honor. But yeah, I don't see anything remand worthy here. And it looks like, the prosecutors are gonna have to look at somebody else if they want a successful conviction on this, just looking at the investigator's report. So asking for personal bond, no objection to a GPS tether with a house arrest, Your Honor. Yeah, I don't see this one going anywhere.
Thank you. Court uses clear convincing evidence standard when it's entertaining a monetary bond. You start out with the personal bond basis. In this particular matter, okay, courts heard the representations from both sides. Courts had an opportunity to review the investigator's report in which supposedly Mr. Braxton, he was seated in the driver's seat. There was two other people that got out that were basically either attempted or did an armed robbery. On the complaint, Mr. Jones, allegedly it was Mr. Braxton's vehicle that allegedly that participated or was the suspect vehicle. Not only that, supposedly, Mr. Braxton made some statements that he and his friends planned on robbing Mr. Jones of his firearm. Those are the allegations. And if this had occurred months ago, maybe there'd be an additional information. Maybe the court would look at it differently. But in this case, the court sees Mr. Braxton as a danger. And under the court rule 6.106, okay, if he's charged with armed robbery and the court finds proof of his guilt is evident, presumption is great, he can, in this particular matter, as well as he can be remanded unless, not likely to flee unless, or he doesn't present a danger. The court does believe that he's a danger, so he's going to be on remand status. However, Mr. Braxton, that means no bond for you, but I'm letting you know is that even though with that no bond, whoever your attorney is can approach Judge Jefferson before your court date of February 12th and see about adjusting the bond amount and bond condition. Do you understand that, sir?
Yes, ma'am.
That concludes your arraignment, sir. You can step aside.
Thank you, Your Honor.
Your Honor.
Thank you.
Yeah, it's turn on. He's in five.
Take phone. Marcus Deion Cooper II.
Mr. Cooper, hold on. Officer Delaney,
Yes, Your Honor.
is there any other information you needed?
There is not, Your Honor. I appreciate your time.
Thank you. You have a good day.
You as well.
All right. Gentlemen at DDC, you said you're Cooper, sir?
Yes, Marcus Deion Cooper II, ma'am. Your
Thank you,
Honor, I'm
Mr. Cooper.
sorry.
Administrator, check that. You're here on a criminal matter, case number 250-55-60301. You have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Marcus Cooper. He stands to me waives the reading of the information after the plea of not guilty be entered on his behalf. Mr. Cooper has been advised of his rights, Your Honor.
Thank you. I'm gonna enter plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Taylor. Mr. Cooper. Bond conditions are you obey all your bond conditions, don't get into trouble, and go to court when you have to. Do you understand all that?
Yes, ma'am.
Okay, and Counsel Ragland, court is aware that he has 2 convictions out of Macomb County, assaultive. Let's see, commit. It just says attempt to commit a felony and GBH. And then there's also fleeing police, 3rd degree. DDC.
I do.
Yes, okay. DDC, can you hear me? Can you tell me in reference to Mr. Cooper, are there any holds on him?
He's got 3.
I heard is that he's got 2. He's got 3 holds?
Yes, ma'am.
Okay, are there any monetary bonds on him?
No. He had 3 holes, Your Honor. I don't know if he heard me.
On his monetary, on his pending cases, does he have monetary bonds or does he have remand?
Oh, 3 holes, no money?
Monetary.
There's monetary?
Yes.
Okay, all right. Thank you. Go ahead, Counsel Ragland.
Well, people are gonna ask for a 10,000 cash surety bond, Your Honor. We were gonna ask for a tether, but apparently it wouldn't be necessary since it's got these other holds on it. Thank you.
Okay, thank you. Go ahead, Counsel Stevenson.
And I would argue that the monetary bond is not necessarily if he has the other holds on him. I don't know that the monetary bond is appropriate in this non-assaultive charge. It looks like Mr. Cooper is seeking employment at this time, Your Honor. He does some self-employment work, Your Honor, but he's seeking something a little bit more steady. And again, this is a non-assaultive charge. If he does have other holds, then those jurisdictions can deal with whatever they have to deal with, looking especially at what there may be something from probation regarding that January 25th of 23 conviction. So I'm asking for personal bond on this non-assaultive charge, Your Honor.
Thank you. DDC, are those holds, are they parole detainers? Or just regular probation violation matters? I'm sorry, DDC, I didn't hear everything. I'm sorry, DDC, I didn't hear it. Can you repeat again?
It's just regular courtrooms.
Okay, regular courtrooms. And are those for GBH? And is that for fleeing?
They don't list the charges.
They don't list the charges? Okay.
No, Your Honor, they
Is it
just
out
list
of
the
Macomb
courts.
County?
Centerline, 1, and Lincoln Park.
So Lincoln Park's out of Wayne, and the other two, Center Line. And at least one of them appears to be out of Macomb County. So, all right. Anything else, Council Ragnan?
Nothing further.
Anything else, Council Stevenson?
No, thank you, Your Honor.
Court's heard the representations in this particular matter. He's got at least 2 or 3 matters. We're seeing that he's got 1 matter out of Lincoln Park, Wayne County. He's got at least 2 matters out of Macomb County. Okay. And he's got monetary bonds for that. And out of Macomb County, he's got 3 convictions. Assault with intent to do great harmless and murder, a flee in 3rd degree, as well as one is says a felony or attempt to commit a felony. Okay, looks like it's all 1 incident. Okay, so what I'm gonna do is I'm gonna give Mr. Cooper a $50,000 personal bond. However, okay, because that there is he has 3 cases that may or may not have impact, but in this matter, make sure. So even though it's a stolen vehicle, traveling at high rate of speed, disregarded red light, it doesn't show, even though disregarded, but it doesn't show that there was assaultive behavior. So while this court was thinking of giving him a GPS tether, okay, he was there with the police, even though high rate of speed, but no assaulted when the stop was made. So I'm going to stay with the $50,000 personal bond. Mr. Cooper, you still have to deal with your other matters. Do you understand that?
Yes, Your Honor.
Okay, that concludes your arraignment. You can step aside.
Thank you, Your Honor.
Thank you.
What's your name, sir?
Mario Antoine.
Mr. Reynolds, I'm Magistrate Chate here. Criminal matter, case number 250-5560601. Sir, you have an attorney. Go ahead, counsel.
Janice Stevenson appearing on behalf of Mario Reynolds stands mute, waives the reading of the information, asks to the plea of not guilty, and on his behalf, Mr. Reynolds has been advised.
Thank you. It's been advised of his constitutional rights. I'm going to enter plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Robbins. Mr. Reynolds, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes.
The charge is non-assaultive. It is January 31st, 2025. He has local ties. Disqualified to carry a concealed pistol. Counsel Ragnan, is there anything you want to let me know?
No, we were just going to ask for a $10,000 personal bond.
Okay, and I know Counsel Stevens is not going to object. So, Mr. Reynolds, you're getting a $10,000 personal bond. Nobody has to pay any money for you to get out of jail. Go to court and take care of your matter. Do you understand that, sir?
Yes, ma'am.
Good luck.
Thank you.
What's your name, sir?
Harold Joanne Newsom Jr.
Newsom, right? Last name?
Yes.
Thank you, Mr. Newsom. I'm Magistrate Chate here in a criminal matter, case number 250-5560701. You have an attorney. Go ahead, counsel.
Janice Stevenson on behalf of Daryl Newsom, he stands mute, waives the reading of the information, asks that the plea of not guilty be entered on his behalf. Mr. Newsom has been advised of his rights, Your Honor.
You have an entry plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Robbins. Mr. Newsome, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
Okay, well, that being said, this is CCW, non-assaultive. I don't see anything in the court file. I see that he has local ties out of Redford. Council Ragnan, recommendation, please.
People are asking for $10,000 personal bond.
Okay, all right, Mr. Newsome, you're gonna get a $10,000 personal bond. This court notes that your attorney would probably be asking for that, and she has no objection. So that means nobody has to pay any money for you to get out of jail. You understand that, Mr. Newsome?
Yes, ma'am.
Go to court, handle your matter. Thank you, and step aside.
Thank you, Your Honor.
What's your name, sir?
Brian Devontae Richardson.
Richardson, right?
Yes, ma'am.
Thank you, sir. Mr. Richardson, I'm Magistrate at Chabot. Are you here on a criminal matter? Case number 250-5560801. You have an attorney. Go ahead, Counsel Stevenson.
Janice Stevenson on behalf of Brian Richardson. He stands mute, waives the reading of the information. After the plea of not guilty in his behalf, Mr. Richardson has been advised of his rights.
I'm going to enter a plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Robbins. Mr. Richardson, you're not to possess any firearms or any other dangerous weapons. You understand that, sir? With that being said, the charge is not assaultive. He has local ties. I do see that he has a 2008, which is more than 10 years conviction. Counsel Ragnan, what's your recommendation?
Well, people are asking for a $10,000 personal bond, Your Honor.
Okay, that being said, Mr. Richardson, you're getting a $10,000 personal bond. The court knows that your attorney is gonna be asking for a personal bond. She's not objecting. That's why she's not saying anything. So you're gonna get a $10,000 personal. Nobody has to pay any money for you to get out of jail. Go to court, handle your matter, abide by your bond conditions. You understand that, Mr. Richardson? Okay, thank you, sir. That concludes your matter. You can step aside. What's your name, sir? I'm sorry, say that again.
Dion Blunt.
Is it Deanne Jerome Blunt, sir?
Yes.
Okay, thank you, Mr. Blunt. I'm Magistrate at Chabot, sir. You're here on a criminal matter, case number 250-5560901. Sir, you have an attorney. Go ahead, counsel.
Janice Stevenson on behalf of Dion Blunt. He stands mute, waives the reading of the information as to the plea of not guilty be entered on his behalf. Mr. Blunt has been advised of rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 12, 2025, probable cause conference, followed by preliminary examination, February 19, 2025. Both matters are in front of Judge Taylor. Mr. Blunt, you are not to go back to the Shinola store that is located on Canfield. Do you understand that?
Yes.
Okay. All right. Counsel Ragnan, I see that he has prior convictions, Oakland County, St. Clair County. But what I don't see is, except for one, 2017 assault or resisting obstructing, St. Clair County. The rest appears to be retail fraud. Go ahead with your recommendation.
Well, Your
sir.
Honor, there, at least my count, I have 18 convictions for retail fraud. You have 12 of which are retail fraud first. This situation is he goes in the Shinola store.
No, I got that. Counsel Ragnan, tell me what's not in the investigator's report. That's what I want to know.
Why he does this, I have no idea.
Okay, so why he does it, I don't know. He may be
But, Your Honor,
he may be homeless, he may number other reasons. Maybe he likes to steal. I don't know. I don't
Well-
know any of that. So tell me anything new that this court is not aware of.
Well, this just happened yesterday, so I don't have anything new since then, Your Honor, but let me just tell you this.
So
I may,
he's got a multiple convictions of retail fraud.
he does. I don't think it'll stop.
Okay.
So, you know-
Anything does he have? Do you know anything that he has as to any pending cases? Assaultive.
No assault. No.
Okay.
Sex
Counsel
offender.
Stevenson,
Yeah, go ahead.
go ahead.
I'm fine. Go ahead, Ms. Stevens. Tell me what I'm wrong.
Thank you, Your Honor. And, you know, I see the criminal history too, but, you know, right now, the Constitution's still working and, you know, he's presumed innocent of this charge at this point, Your Honor. Mr. Blunt is 58 years old. He's given us address where he lives. I don't see anything with convictions to show that he didn't come to court like he was supposed to. So I don't see any evidence. He presents a risk of flight. We would have no objection to prohibition against having contact with the complaining witness. And I'm asking the court to release Mr. Blunt on personal bond. And again, I don't have any objection to no contact with the complainant, Your Honor.
DDC, Officer Prey.
Yes, Your Honor.
Or you, officer, and I don't know your name, and I'm sorry, I don't.
Gowdy.
What's your name?
Officer Gowdy.
I'm sorry, I only got half of it. Say that again.
Gowdy.
Dowdy?
G, like goat, ghost, gimme. Gowdy.
Gowdy. Okay, Officer Gowdy, can you tell me in reference to Mr. Blunt, does he have any capious history? Gowdy. Okay, Officer Gowdy, can you tell me in reference to Mr. Blunt, does he have any capious history? Are there any warrants out for his arrest?
Warrants.
Warrants, okay, thank you. So that doesn't, so that at least tells me whatever cases he has, he is going to court or he's resolving his matters, but there doesn't appear to be any capious history. So, Mr. Blunt, you're gonna get a $25,000 personal bond. Go to court, handle your matter. Nobody has to pay any money for you to get out of jail. If you don't go to court or you don't handle your matters, break bond conditions, next time it's gonna be a monetary bond. You understand that, Mr. Blunt?
Yes.
All right, thank you. You can step aside.
Thank you, Your Honor.
Your Honor.
What's that?
What's your name, sir?
Landon DeAndre Roney.
Mr. Roney, this magistrate at Chartea, you're here in a criminal matter. Case number is 250-556-1001. You have an attorney. Counsel Stevenson, you wait for him to read and stand mute.
Please, Your Honor, Mr. Rowney has been advised of his constitutional rights.
Thank you. I'm going to enter plea of not guilty. Court dates are February 11th, 2025, probable cause conference, followed by preliminary examination, February 18th, 2025. Both matters are in front of Judge Robbins. Mr. Roney, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
With that being said, the charge is non-assaultive. He has metropolitan ties. This is from just a couple of days ago. Counsel Ragnan, give me a recommendation, please.
People are asking for a $10,000 personal bond.
Thank you. And counsel, and Mr. Roney, you're gonna get a $10,000 personal bond. Your attorney is not objecting because I know that's what she wants. Nobody has to pay any money for you to get out of jail. You understand that, Mr. Roney?
Yes, ma'am.
Okay, that concludes your matter. Handle your matter. Good luck. Step aside, sir. Thank you.
Thank you.
What's your name, sir?
Jalen Davis.
Let's see. Jason Davis?
Yes, ma'am.
Mr. Davis, this magistrate out there, you're here on a criminal matter, case number 250-556-1101. You have an attorney. Go ahead, counsel.
Janice Stevenson, on behalf of Jalen Davis, he stands to me waives the reading of the information as to the plea of not guilty. Enter on his behalf, Mr. Davis has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are November 11, 2025, probable cause conference, followed by preliminary examination, November 18, 2025. Both matters are in front of Judge Jefferson. Mr. Davis, let me tell you a couple of bond conditions. One, you're not to possess any firearms or any other dangerous weapons, and you're not to have contact with these individuals, Shivas Matlock and Iris Martin. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. Do you understand those bond conditions, sir?
Yes, ma'am.
Okay, with that being said, Counsel Ragnan. Okay.
Yeah,
Give me
people
some
are asking
information
for,
I don't know.
we're asking for 150,000 cash surety bond, Your Honor. Very dangerous situation. He shot 4 times at the, allegedly shot 4 times at the complaining witness, who was shot in the wrist area of his arm. So I think that he is a danger to the public. He didn't know these people. Little traffic incident, and they ended up shooting. And he yelled, "Don't get you and your bitch killed." And that's when the complaining witness rolled up his window and he shot 4 times at the kill. He admitted this, by the way, and they did find the force. Thank you.
Thank you. Counsel Stevenson, go ahead, please.
So, not taking the investigator's report as completely factual or complete rendition of the incident, Your Honor, but the people know that there is some arguing that's going back and forth between the parties that looks like it was started by the complaining witness. This is not just some kind of traffic thing. It's really, it looks like road rage, Your Honor, and the complaining witness was not able, according to my quick review of the investigator's report, to properly identify Davis. This is a pretty scary situation. Mr. Davis definitely does not want to have any contact with individuals, Your Honor, who were, started arguing with him. Mr. Davis is 23 years old. I don't believe he has any criminal history, Your Honor. Not sure about any traffic history, but no criminal history that I am aware of. I would have, due to the nature of the offense, Your Honor, no objection to Mr. Davis's not being able to operate a motor vehicle for some time, or at least that privilege being restricted. But I don't see anything in this situation or any kind of criminal history that indicates he won't come to court and abide by any court orders. So I'm asking the court to release Mr. Davis on personal bond. No objection, to no driving if that's going to be the order of the court, but I don't see any reason why he wouldn't come to court. And there's nothing to indicate that he's a danger to the community. Nothing's been.
Thank you, ma'am. Court's heard the representations, both sides use its clear and convincing evidence standard when it's entertaining a monetary bond. The court is entertaining a monetary bond. Started out with a personal bond basis. While there is no specific identification of Mr. Davis by the complainants, there is identification of Mr. Davis driving the motor vehicle that was allegedly involved with shooting of the vehicle belonging to the complainants, or at least one of the complainants. And then supposedly, Mr. Davis did allegedly make some statements and some statements that he did fire. Well, no. Yes, that he did fire his firearm, his handgun, at least 3 times before the unknown male did. So this is a case that the charges are very serious, but we're looking at the allegations. And the court does believe the allegations does support the charges. The court does find Mr. Davis a danger. However, in this particular matter, neither of the complaints have identified him directly. There was through identification through other means and other evidence. So the court is going to go with a cash surety bond. $75,000 cash surety. It's going to be also be placed on a GPS tether. Counsel, does he work, Counsel Stevenson? I can't remember.
I don't have a regular work schedule, Your Honor. I think he works as an independent contractor.
Okay, well, with that, then it's going to be house arrest, and that issue going to be brought up because this is an unaffordable bond, correct, Counsel?
That's correct, Your Honor.
So, Mr. Davis, you're going to get another court date. That would be this Monday. It's going to be February 3rd, 9 o'clock in front of Judge McConicle or Judge Williams, who will look at the bond amount and bond conditions. Do you understand that, sir?
Yes, ma'am.
So I got the bond conditions, I got the bond amount, and I am placing you on GPS tether, house arrest. However, those issues will be brought up to Judge McConicle or Judge Williams when they look at your bond amount. Do you understand that, sir?
Yes, ma'am.
Okay, that concludes your arraignment, sir.
Thank you, Your Honor.
Thank you. What's your name, sir?
Charles Dunn.
Mr. Dunham, this magistrate up there. You're here on a criminal matter, case number 250-5561-201, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson, appearing on behalf of Charles Dunham. He stands mute, waives the reading of the information. After the plea of not guilty be entered on his behalf, Mr. Dunham has been advised of his rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Taylor. Mr. Dunham, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that?
Yes.
Okay. All right. Counsel Ragnan, go ahead with your recommendation, please.
Now, the people are asking for $30,000 cash surety bond. He's able to post the bond, tell their home arrest. No firearms. Yeah, this is a shot spotter investigation by the police. When they get there, the defendant tells them point blank that he was the shooter, and that nothing can be done to stop him from shooting. Take me to the judge so I can tell him, let this gun off. I'll bond out, and then I'm going to keep shooting. Explains that he has been.
Yeah.
Counsel Ragnan?
Okay. Yes, I've read that. Tell me something that I don't know.
There's nothing new that I have out of this report, Your Honor. It seems like he does need some treatment and some help, and I wish he could get that for himself. But I think he's very dangerous. I mean, they found ammunition in his vehicle and in his home. They found the AR-15 rifle, and shell casings where the shots were fired from him. So, I think he needs to protect the public and the people, because he says he's going to do it again. I think the cash bond is necessary in this incident, and have their home arrest if he's able to post a bond. No guns.
Thank you. Thank you. Counsel Stevenson.
Your Honor, I am going to ask that the file be marked medical. Mr. Dunham going through a lot right now. He does own a landscaping company, Your Honor. It looks like might have been arrested at the hospital, Your Honor. So definitely we are going to ask for his file to be marked medical. He does have some medication needs. I do want to be sure that he's getting those. I'm not certain if he is at this time, Your Honor, but we would ask the court to mark the file medical. We'd ask for personal bond or nominal bond, Your Honor. Understand the condition, the probable condition of the house arrest, but definitely more than anything else, we want the file marked medical.
Thank you. DDC, can you mark Mr. Dunham's file medical? I need a response, DDC. Is that a yes?
Yes. Yes,
Thank you. With that being said, court uses clear and convincing evidence standard when it's entertaining a monetary bond. We start off with personal bond basis. This is very concerning to this court. These were shots fired, and allegedly Mr. Dunham made some statements that he's going to continue to shoot his guns, his firearms when he wants to, where he wants to. Okay. Even though that he has a concealed pistol license, if it's taken it away, he will go to another state, he will get another one, but nothing is going to stop him from shooting his guns. And the thing is, for Mr. Dunham, is he shoots his guns, those bullets, wherever they're coming from on his firearms, they're going to come down. And in that, okay, that can make him a very dangerous individual. Not only that, he may hurt himself, but he may hurt other individuals, especially, and it may not be an intentional, but if he's firing his guns when he wants to, where he wants to, other individuals may be hurt. Don't know. I hope not. And I see that he is having some issues, that he suffered some negativity or tragedies in his history, family history. And I'm sorry about that, Mr. Dunham, but you can't go and do, and you don't need to respond, sir. You can't go and shoot your guns when you want to. Those are the allegations, sir. The court does find you as a danger. The court is going to put recommendation, adopt the recommendation, $30,000 cash surety. You're going to be on a GPS tether, home arrest. You are going to get another court date for, I believe, this Monday, bond redetermination, February 3rd, 2025, 9 o'clock in front of Judge McConigal or Judge Williams, who will look at your bond amount and bond conditions. Do you understand that, Mr. Dunham?
Yes.
Okay. Thank you, sir. That concludes your arraignment.
Thank you, Honor.
Thank you, Your Honor.
Thank you. What's your name, sir?
Johnson.
Mr. Johnson, I'm Magistrate Chapea. Stand by for a moment. Here we go. All right. Johnson, case number, sir, 250556130, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson, on behalf of Demetrius Johnson, he stands mute, waives the reading of the information. As to the plea of not guilty, enter on his behalf, Mr. Johnson has been advised of his right, Your Honor.
Thank you. I'm going to enter plea of not guilty. Court dates are February 11, 2025, probable cause conference, followed by preliminary examination, February 18, 2025. Both matters are in front of Judge Giles. Mr. Johnson, you're not to go back to the Tyler residence. Do you understand that? Thank you. Counsel Ragnan, give me your recommendation.
Yeah, the defendant is on a tether. Excuse me, at the time.
And the tether confirms that he was at that location. So give me other information I do not know.
There was an air tag on the furnace that he had in.
Yeah, I got that also. I'm aware of that.
So we're going to ask for a $5,000 cash surety bond. I was going to ask for a personal bond on a tether, but I don't think a tether does any good. So I don't.
Well, the tether just shows where you're going here and there. So let me ask you this, okay? Has he not, what is the case that he is on tether for? If you're aware.
I don't know.
Mr. Johnson, you don't need to say anything. That's why we have attorneys. Go ahead.
Said I don't, but it's Wayne County for sure. And for some reason, I didn't get a chance to look that up.
Okay, all right.
But Your Honor,
Maybe counsel, go ahead.
It's probably worth 50,000 personal with the tether as well.
Okay, all right. Counsel Stevenson.
So I'm going to concur with the people's recommendation for bond, Your Honor. He's on the tether already. Mr. Johnson is seeking employment at this time. Actually, he does home improvement. You're on 5 days a week from 10 in the morning until 6 in the evening. So we'd ask that he be allowed to go to work. But we would concur with the people's request for bond, Your Honor.
We'd ask for home arrest, Your Honor, please. He's already went out at 5 in the morning.
So we're agreed, everybody's agreed that Mr. Johnson's gonna get $50,000 personal bond. Nobody has to pay any money for him to get out of jail. The question is he gonna be placed on another tether or not? You want a tether, is that correct, Council Ragnan?
I do, and I'd like home arrest. Now, the
Okay.
reason I want to tell
Okay, and I just want to know you want a tether. And Council Stevenson, you objecting or you're not objecting?
I don't object to the tether. I think he's already on it. And I don't think it's been.
Okay, well, I think he should be placed on the tether because I don't know on that other case if they're going to remove it or not. But on this case, he's going to be placed on a GPS tether. And does he work independently, Council Stevenson, or does he work for a third party that you are aware of?
Actually, I don't know an answer to that. I just have the schedule, Your Honor. I don't know if he's working alone or with a company.
Well,
I mean,
this is what we're gonna do. If he's working, is this to rehab houses or something?
Yes,
Council?
Your Honor. Yes.
Okay, well, in this case, he may have been, he's accused of going into a house and taking or participating in taking some items that belong to the house, not belong to him. So I'm gonna place him on a GPS tether house arrest. Councilor Ragnan, did you want to add anything else?
No, Your Honor, that's it. Thank you.
And Mr. Johnson, just so you know, the GPS tether that I'm placing on under this case, you can talk to your attorney and your attorney can talk to the judge of record, Judge Giles, whether to remove that bond condition. Do you understand that, sir? Do you want me to repeat, sir, what I've said?
Yes, ma'am. Yes.
No problem. All right, you're gotten a $50,000 personal bond. Nobody has to pay any money for you to get out of jail. However, this court is making sure that you're going to be placed under a tether under this case. That means, and that the tether, you can't go to work. You have to stay at home. Now, whoever your attorney is can approach the judge of record, who is Judge Giles. Judge Giles can change the bond conditions and bond amount. Do you understand that?
Yes,
is that a
ma'am.
yes? Okay,
Yes, ma'am.
that concludes your arraignment. Thank you, sir. You can step aside. What's your name, sir?
Darnell Salis.
Mr. Salas, this magistrate up there, you hear criminal matter. Case number is 250-4432-601, sir. You have an attorney. Go ahead, counsel.
Janice Stevenson, appearing on behalf of Mr. Darnell Sales. He stands mute, waives the reading of the information, asks that a plea of not guilty be entered on his behalf. Mr. Sales has been advised with rights, Your Honor.
Thank you. I'm going to enter a plea of not guilty. Court date is pre-trial February 10, 2025. It is in front of Judge Austin Garrett. Mr. Salas, some bond conditions. One, you're not to have contact with the complainant, who is Brianna Andrews. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms while this or any other dangerous weapons while this case is pending, as well as you're not to go back to the Shields residence. Do you understand those bond conditions?
Yes.
Okay, counsel Stevenson, does he need a police escort?
Yes, please, Your Honor.
Okay, all right, Mr. Salas, you're gonna have a one-time opportunity with a police escort to go to the Shields residence and get some of your belongings. Do you understand that, sir?
Yes.
Okay, Counsel Ragnan, your recommendation, please.
You're asking for $25,000 personal bond, but we're asking for a tether with a curfew. Your Honor, the incident was observed by a witness that this defendant allegedly strangled the complaining witness, then threw her on a couch, held her down with her knees and her arms. The witness called 911 and then recorded parts or all or some part of the situation. So So I'd like obviously no contact, which you've already said. Thank you.
Okay. Counselor Stevenson, go ahead.
I don't know that there was any evidence of any strangulation, hence the very lowest misdemeanor domestic violence count that they could, Your Honor. Mr. Salas is employed at this time. He's advised us that he can stay with the relative. He doesn't have to have any contact with the complaining witness. He doesn't want to at this time, as the investigator's report indicates that the two were in an argument at the time of this incident. And in fact, Mr. Salas has already called the police on the complaining witness twice very recently. So no contact is absolutely in order. He'll abide by that. We would concur with the request for the personal bond, but we'd ask for the tether to just hold off on that at this time unless Judge Garrett takes a look at this and decides that that's in order. We don't have any capious history, no criminal history that I'm aware of. So there's nothing to indicate that Mr. won't abide by all court orders due to the nature of his work. Your Honor, works as a welder, and the tether is going to interfere with Mr. Salas's ability to work, which is going to interfere with his ability to care for the 3 children that he does support in this community. So definitely I'm asking Ragnar for the personal bond, but I'd ask the court to hold off on the tether unless and until it looks like Mr. Salas is not going to abide by any court orders, because there's nothing to indicate that that's the case at this time, Your Honor.
Thank you. Court heard the representations. We are going to go with a $25,000 personal bond. However, regarding Mr. Salas, the court has a copy of his criminal history. Nothing that I see that is assaultive. Narcotics, we're talking about, it looks like just misdemeanor stuff. Narcotics, drinking and driving, driver license suspended. Other than that, okay, Mr. Salas, if you do not abide by the bond conditions, even though the complainant wants to have contact with you, and if you do, that's a violation, you may be seen at a high monetary bond, along with other bond conditions include GPS tether. Do you understand all that?
Yes, I do.
Okay, I'm gonna give you one chance opportunity. I'm not gonna put, even though the allegations are that you allegedly strangled, but for whatever reason, the prosecutor did not charge you with that. You only charged with domestic violence, a misdemeanor. But any violations, you may have a high monetary bond along with other bond conditions. You understand all that?
Yes, I do, Your Honor.
Okay. And let's see what I needed. Okay. And you cannot go to that residence unless it is one time with a police escort. You understand all that?
Yes.
Okay. That concludes your arraignment. Councilor Ragnan, you want to say anything else?
No, I want to say thank you. That's all.
Thank you. Councilor Stevenson, anything else?
No, thank you, Your Honor.
All right. Thank you.
Your
DDC,
Honor.
thank you very much.
Thank you, lady clerks. And I do have one question, Your Honor. I get about
Okay, hold
15
on. Hold on. DDC, are you done with DDC?
I'm done.
Okay. DDC, thank you very much. Thank you, sir.
Bye, Mr.
I
Gaddy.
will see you tomorrow. Okay. Take care, DDC.
Thank you, officers, Madam Clerks.
Okay, now, what do you want to ask?
Well, I just wanted to mention, I've noticed I get 15 seconds basically to talk about my bond and this.
I'll give you, I give you more than that.
No, I'm just kidding. It's just a joke.
No.
He said, and I
give
get
you
3
more.
minutes. He said, I get 3 minutes.
It's just a
No.
joke. It was a joke.
No,
That's all.
Councilor
I thought it was
Ragnan,
funny
I
about
disagree
myself.
with you, okay?
No.
What I don't want you doing is,
No,
what
I
I don't want you doing is reading the investigative report that what I have read. And
Right,
if
I
it's,
totally
I've done the
understand.
probable cause hearing, give me something that I don't know.
I know that. That's why I enjoy being here with you always, and it's never been a problem. I'm only making a joke. I thought it was kind of funny myself.
Okay.
You did.
Well,
Here's my
I will tell you. I
It's
don't
very
think
funny
15
thinking I get
seconds.
3 minutes.
If you, okay, Councilor Ragnan, I will
Right.
say this, on a number of cases, I didn't even give Stevenson an opportunity. Because I just went in and I said, I don't believe council is going to object.
I
It
like
went
that
right
a
into
lot.
bond.
I think that was great.
Cut me right off. Cut me off.
I like that. Why go on anymore, right? So, no, it's all been
Not
very,
in no 3
very
minutes.
I hope all of you have a nice afternoon and evening, and I'll look forward to seeing you tomorrow.
Not me, not me, somebody else.
All right. Have a good evening. Thank you. Thank you.
No, I am not. No, no.
So
Somebody else, somebody will be here.
Real quick, not me, not me.
Not me.
Your Honor, I wanted to ask you, did you used to have to go to, see you, Ms. Stevens, to the Murphy Hall of Justice on weekends? Did you have to do that before? Now you're doing it from the.
Oh, yeah. Yeah, before, yes, we'd have to go to Frank Murphy. And before, 36th District took care of all of Wayne County, the magistrates needed to go to Romulus.
Oh, really? Oh, wow.
Yeah.
Well, I gotta just tell you real quickly, when I first started working here and we were gonna do looking in to try and maybe do weekend arraignments, right? I'm dressed up, I'm in my suit and tie and all that. And I go to Frank Murphy Hall of Justice and I let the guy let me in. It was empty for the floor with the prosecutor's office. I was walking up and down hallways looking for people, knocking on courtroom doors. Finally, I went back to Doug. I called Doug. He said, go back to 36, and would you please? So anyhow, but I'm glad you don't have to go there. That's
okay. I don't know if you're going to come in for Out County. It would be nice if I saw you in person. At least some of the attorneys here, even if the defendants are on Zoom, it would be nice. But okay, we got what we got.
We do, but I always enjoy it. So thank you. All right. Thank you, Madam Clerk.
Yes, sir. So I will see you tomorrow.
All right. Thank you.
Take care. Bye. Council Reagan, I will see you tomorrow.